Please be seated. Yes, Mr. Future.
May it please the Commission. Mr Sargent, have you had an opportunity over the lunch break to consider the agenda and the minutes for that meeting?
Yes.
Thank you. Does that refresh your memory about the deliberations of the GWC at the meeting in June concerning that policy?
Not much, I'm afraid. Let's see what you're going to ask me first, and I'll see how we go.
Right. Well, do you recall in June this year there was a meeting of the GWC?
Yes.
You attended that meeting by some electronic means?
Yes.
And one of the items concerned a change in the policy relating to FPOS.
Yes.
And that change in policy was approved at the meeting?
Yes, it was signed.
And do you have an understanding of what the effect of that policy change is on the ability of patrons of Crown Perth to withdraw funds using FPOS?
At designated areas.
At
yes.
designated areas. And do you understand the limit to be a limit of $400 per transaction?
And also $500 in total, I think. Is that
correct? $500 for the day. So,
yeah.
So just to be clear, does that mean, for example, a person can withdraw up to $400 at a time, but no more than $500 in a day?
That's the intention, yes.
Now, do I understand the GWC has previously approved the ability to utilise FPOS at designated areas within the casino. The policy now overlays that and places limits on how much can be withdrawn. My question is really, how do those changes sit with the previous ATM policy that required patrons to have a limit on the withdrawals from ATMs within the casino and for the ATMs to be more than 40 metres outside the footprint?
Well, it was a development in the services provided to patrons that many patrons were wanting, apparently, from my understanding, to use the FPOS facilities. There was some requirement in the resolution for some extra work to be done over time to see how it went. So it wasn't a matter of, say, I think the number that had been approved previously was to stay at that number, and they're going to see how it operates over time. And I think, if I remember correctly, the RSG people were asked to provide some input too as well.
The driver for it is, if you like, a change in consumer behaviour towards cashless transactions.
That was my understanding, yes.
And would you agree that that kind of change is likely to continue in the future? Well,
it may not in the case of these particular FPOS machines, because there is a requirement for them to report back to see how it's going. So there may not be an expansion.
We might be at cross purposes, Mr Sargent. What I'm talking about is, as a matter of, given the COVID pandemic and the shift towards cashless transactions in general, the demand by consumers to have that convenience is likely to continue in the future.
Well, I can't commit a future, Commission, but I would suggest so.
So what I wanted to ask of you, Mr Sargent, given your experience for many years, is whether you would consider a possible risk faced by the regulator in the future is managing increasing demand for cashless services.
Well, it's not something that would be difficult for the regulator to withdraw or to put a stop to if the evidence was being produced that there are issues as a result of this facility. But at this stage, I think given the trends, it's a good chance that it will continue. But as I said, that depends on the future composition of the Commission.
I see. And based on your knowledge, do you consider the readily available funds to be an aspect of that may create a greater chance of gambling-related harm?
There's always that possibility, yes.
And aside from placing limits on the amount that can be made available, are there any other controls that, in your view, could be implemented to manage?
One of the controls was to make sure that all staff were again trained in trying to assist people who might observe, or to observe people who might have issues to do with gambling, and they were also required, they had to use a PIN, not to just use cashless. And I think one other thing was that it had to be shown as a transaction for a casino. You couldn't disguise it as something, as a transaction for some other name. It had to be that the transaction appeared on the patron's statement as a casino item, if I recollect correctly in that regard.
All right. So in terms of the similarities with the ATM policy that preceded it, or that was amended, is the need to go to a designated area and put in your PIN something equivalent to having to go to an ATM to get cash?
It does create a break, but it wouldn't be as long a break as going outside the casino footprint to get cash from an ATM.
So what is the rationale underpinning the 40-metre requirement then, the break? What's the harm minimisation aspect of that?
I would suggest we had some consistency with Victoria on that one. They had a 40-metre one at some stage, so we just applied the same in WA.
Is there any statistical information to suggest that a break in play of a period of time is beneficial from a harm minimisation perspective?
I'm not aware of any like that sort of break. But I think intuitively you could say if a person was to leave a table or to leave a gaming machine, there might be a chance they might say, "Oh, I won't get any more money, I'll go home." If they're having too much, they're spending too much, there's a chance. But I'm not aware of any statistical information to support that proposition.
I see. So it's based on an intuition that
More intuitive, yes.
If you cause a person to stop playing for a period of time, it may temper their desire to continue betting.
Correct.
Okay. Mr. Sargent, can I ask you about another topic you've dealt with in your statement, which is find the right statement, sorry. This is the change to the speed of play in 2019.
What number is that one again? Can you remind me?
It dealt with in paragraphs 84 to 87 of your statement.
Yes, thank you.
And if I could just begin with, you make reference in paragraph 84 to the resolution in 2019. And your understanding that it had an effect on the WA appendix is referred to in paragraph 85. Now, all other things being equal, I'm going to use the expression change of speed to avoid the possible confusion about decrease and increase. A change in speed from 5 seconds to 3 seconds, all other things being equal, means a patron can play more times or games within a given period of time.
That would be my understanding too, yes.
And going back to some of the evidence you gave before lunch, that would mean in a given period given the odds are in favour of the house, as it were, a patron may lose more in the same period of time.
I could interpret it that they would lose their money quicker, but I think your analogy is equivalent.
Yeah, so if you had unlimited funds and you paid for the same length of time, on average, you're going to lose more over that period of time.
That would be the maths of it, yes.
And the corresponding part of that equation is that the casino earns more in the same way, that the patrons lose more.
They'd be winning more.
Yes. Now, you have set out in paragraph 86 some of the reasons that you considered were taken into account for agreeing to the change in the speed of play. I'd just like to ask you to elaborate on some of those a little more, if you may, if I may. In 86.1, and you might recall when you began to give your evidence yesterday, you changed the word decreasing to increasing.
Correct.
And you've referenced there the fact that, let's just say, changing the speed of games. You then say, and my understanding of problem gambling issues that may arise from that change. What are you referencing by when you refer to problem gambling in that sentence?
Well, the issue that you've just raised was the fact that in a given period of time, the patron could lose their money quicker. And so if you have got a person that does have a problem with gambling, they'd either, well, hopefully they'd go, but they might try and access additional money or use more money than they anticipate. As against that, we talked this morning about the figures which I was familiar with in relation to Australian Gambling Statistics figures, and that in WA, the trend line was down rather than up in terms of the average, the real amount per person in the WA was declining. That is in relation to the expenditure on gaming. So that was one concept that I was looking at, this particular proposition. And the other major one, because I've listed the three of them, but the other one, of course, the majority of Crown's submission was about the economics of the casino, which I understand previous witnesses have referred to here, and that they were looking to looking to generate more revenue for the benefit of, ultimately they were saying, for the community, a sense of facilities and employment. But the amount of money that they were proposing that would be generated from that wasn't a big amount in the overall context of the running of the casino. So they're the sort of issues that were being considered by the Commission. I can assure you the issue of problem gambling was discussed and people were very much aware of it in arriving at that decision.
All right, you've anticipated where I was going with some of my other questions, Mr. Sergeant, in that answer. If I could just come back to paragraph 86.1 for a moment. So you've mentioned, I think you began by really referencing the financial harm associated with the speed of play. Are there any other aspects of speed of play that have, if you like, a propensity to lead to a gambling-related harm? For example, does it make it a more addictive type of game?
I'm personally not aware of whether the speed does make it more addictive. I'm aware of some research which has looked at the design, etc., and the way in which the games are presented. I'm not aware of it in terms of speed, but I'm not aware of anything in that regard.
Okay. So in 86.2, you've made a reference to trends in EGM design and the move towards in-game features. What do you mean by that?
Well, as you're aware, the Commission subscribed to the National Working Party, and the National Working Party with respect to gaming standards was allowing in-game features to be developed. So this was a trend which had been happening over time, that the machines generally being placed on the market were ones that have these in-game facilities. So that was just a conscious aspect of my decision making. That was something which over time the Commission had endorsed, in the sense we'd allowed many machines and many games coming into the casino which had these add-on features. So that was just an aspect of the arrangements whereby machines were complying with the national standards for gaming machines.
But how does that feature in the decision to approve a change in speed?
Well, the change in speed in this particular case was very much associated with in-game features. That is, from my perspective, if you recall, the proposal came in from Crown was for a 3-second minimum speed across the board, not 5 seconds across the board. Now, I personally was not supportive of that, of across the board. I think many other Commission members were not. However, as part of the discussion and the weighing of the arguments of the economics versus the harm, and considering we did allow for the add-ons to become part of the game features, one of the compromises was to say, well, back in 1985, when the machines were first allowed in the casino, there was no add-ons. They had a 5-second minimum play period. So the proposition, which I think was ultimately adopted, was to say any games that have a add-on feature, they can go down to a minimum speed of 3 seconds on the condition that, on average, over the use of those games, the average speed time was 5 seconds. In the case of any machines or games which didn't have the add-on features, the minimum time was 5 seconds. So they couldn't introduce a game which had no add-ons to be less than 5 seconds. And that's the way in which it was adopted. There was a condition on that approval that Crown would come back subsequently with some evidence to substantiate that the 5-second rule the 3-second rule in relation to those add-on games was actually generating, on average, a 5-second game. Because Crown was arguing with support of GLI that their games were not averaging now 5 seconds, they were averaging 8 seconds.
And did you undertake any interrogation of that statistic of 8-second average?
We accepted the GLI's report on that.
And
I'm pretty sure GLI had done it.
And do you know how they calculate the average? Is it based on...
Look, how they even verify machines, I'm afraid I'm not confident enough to comment on it. You just accept their recommendation that when a game's presented, there's a certain payout ratio, there's certain features, they test those machines to say, over time, they will generate those figures.
I see. So the intention of your understanding of the intention of the GWC's approval is that whether, irrespective of the reference of three seconds, provided that the game has in-game features, and on average the average time between games is 5, it's acceptable. Not between,
but average time of playing a game, minimum time would be 5 seconds. Minimum. Ideally, it might even have been 5.5 or 6, but had to exceed 5 seconds. Couldn't go below 5 seconds.
All right. Can I just take you back to the agenda? Make sure I've got the right one. Sorry, Mr. Sergeant, let me find the right one. Yes, so I don't believe this is referenced in your statement, Mr. Sergeant. This is a agenda paper for the July meeting in 2019. It's GWC.0002.0016.0281. You have referenced, Mr. Sargent, in your statement, I think the minutes of the meeting, which reflect your view of what the GWC had resolved.
That may not be the case, Mr. Future. Anyway, perhaps we can ditch the comment.
Sorry?
I said perhaps we can ditch the comment because I'm not quite sure that the paper does reflect what the GWC decided.
Yes. Could I ask that you navigate to page the underscore 0030. These are attachments to a agenda paper that Mr. Connolly prepared, Mr. Sargent. I'm just seeking to clarify a few matters arising from these. If on page on that page I've given you, which is 0030, there is some words that are struck through in blue, which is to do with where the symbols are placed. I think you may have referenced this in your statement about the independence outcome factors. And then the speed of play reference is in item 2. You'll see it struck out the 5 and gone to 3. And then there are some others in item 10 on the following page where items are struck out. And ultimately, the next document is a policy, which is the EGM policy, where some amendments were proposed to that. And can I draw your attention to one, which, sorry, you'll need to scroll up. So one, you'll see there's some lines that are struck out that appear to correspond to the positioning of the symbols, and there's an item there dealing with speed of play. Then there is another item which is called winning under the heading winning combinations, that where various things are struck through, and it makes reference to multi-line and multi-directional winning combinations are not acceptable, and that's been struck through in the policy. Is it your understanding that the GWC at any time approved a change in the EGM policy to remove the references to prohibition on multi-line or multi-directional winning combinations?
No, because it wasn't in the minutes.
And was there any discussion, to your recollection, about multi-line or multi-directional?
I can't recall a discussion. It was more about the 3 seconds. But bearing in mind, the Commission didn't endorse that recommendation.
Did not endorse it?
No, because it was a 3-second recommendation. The Commission didn't go down the path of just 3 seconds.
And this is your reference to the minutes in your statement where
those minutes are not as per the recommendation.
correct. So if I could take you to the minutes, which are on page GWC.0002.0016.0285 _ item 5.3. And that's consistent with the evidence you gave earlier about the way in which the speed of play is to be calculated, and there's no reference there to any changes to the policy.
No, at that stage, because this was contrary to the policy the policy would have had to have been amended to be consistent with this. So there's only 2 items there. The independence of outcomes, Crown got GLI to make an assessment of it. I know that one's one we accept. I'm not sure why we didn't accept the other one, but it wasn't in the minutes. So my recollection is that they were the only 2 things that were agreed to, the 3 and 5 seconds and the independence of outcomes.
All right.
With all due respect to both of you, this is the point that I was making before. Mr. Sargent, what is written there as the resolution does not in any way reflect what you have described as being the resolution, the decision made by the GWC. Does it? It doesn't have anything in there about average speed of play.
I'm with you. It just says a speed of 5 seconds when no game features are incorporated.
Yeah.
No, point taken.
Is your evidence your understanding of the resolution was to have that effect?
Yes, it was to have that effect. Otherwise, well, I know I wouldn't have voted for it because it had to have that proviso. To some extent, the minimum speed of game, where no game features are incorporated, it's fine. It's where the 3-second one is required, and that's where, as the Commissioner's pointed out, the minutes do not reflect that decision at all. No, she's quite correct. But that was the intention.
Now, can I ask you something about the multi-directional, multi-line concept?
Yes.
Why is that under the EGM policy an option that is precluded?
Well, it's one of those features which appears on a machine where you can play the spinning wheel machines, whereas we were limiting our machines to vertical and horizontal outcomes, fundamentally.
And what's the rationale for the limitation for not allowing?
Well, it means that with more lines, you can actually bet more because there are more options available with a multi-line game, whereas when you only got vertical or horizontal, it limits the number of options you've got to gamble.
And so is that an aspect of harm minimisation, is it?
Well, it's harm minimisation, but it's also, again, to draw a distinction between a spinning wheel poker machine versus the EGMs that are allowed at Crown.
All right. You've just made reference to a topic I wanted to ask you some questions about, Mr. Sargent, which is the notion of a poker machine and how the EGM games that have been approved are differentiated from a poker machine. What is your understanding of the meaning of a poker machine?
Well, the fundamental thing to me is a spinning reel. That is the results of the game are presented in the form of spinning reels, which is a product of the old one-arm bandits, which presented their results through spinning reels. That's fundamentally the difference.
So,
the way you present the product.
Is that the, if you like, in your mind at least, the feature that distinguishes an EGM from a poker machine, whether there's a spinning reel feature?
Yes.
Are there any other aspects of, it's a visual thing, is it not? That you're looking at the way that the game presents visually?
Well, the other one was a multi-line betting on a poker machine. That is, we only limit them to the vertical and horizontal. But the multi-line option is also as a feature of the spinning reel machines.
I see. So is the multi-line, multi-directional a key factor in your mind for differentiating between an EGM and a poker machine?
To me, yes.
In your statement, you have given some evidence at paragraph 77 to 79 concerning the approval process for EGMs. And I understand from paragraph 78 that if the EGM is a clone of a previously approved EGM, and in principle agreement is provided, in principle approval is given, then the process is that the matter is then dealt with, at least at this time, was then dealt with by the chief casino officer to, under the delegated power, to put into effect changes to the rules.
Yes, once the machine was ready to be approved, rather than bring the very minor changes to the rules back to the commission, it was delegated to the chief casino officer, correct?
And what do you mean by a clone? What's your meaning there?
Well, to me, fundamentally, the principles of the machine, the game are the same. It just might be how they present the symbols, and or the bonus features normally might be a bit different, but fundamentally the game rules are the same. But even if it was a new full game, the presentation would be exactly the same. The only difference would have been the rules would have had to come back to the commission. They would have been approved in the case of something which is just a clone machine that's delegated to the chief casino officer. Otherwise, we'd have to come back to the commission.
Okay. Are you familiar with the various approved games under the GWC Act?
Do you mean the process, or do you mean the actual all the games that are approved?
The games that have been approved.
No. It's not a highlight of my working time to know that the games, particularly in the poker machine area, the game machine area.
Did you have in your role as chairman of the GWC, did you gain an appreciation of what electronic gaming machines were approved?
Well, basically saying any game which was not a poker machine, but I remembered fundamental games like draw poker and blackjack, bingo, and then a whole range. Some of the games could have been approved, and then Crown may have stopped using them, but they never get taken off the list. But I'm not in a position to recall at any time exactly all the games that were available.
All right.
On the floor.
Could I ask, we call up GWC.0001.005.0025? And if you look at under item 3, sub 2, there's a list of declared authorised games. And this is in the Government Gazette, at least as of August 2016.
These are table games, if I remember correctly.
Is Arashenko, do you understand that to be a table game?
Where's the Arashenko one?
Under 7 card stud.
I don't know, Arishink, I don't know.
You don't know?
What's on the other table? What games are they? Can you make them a little bit bigger for me, please? Well, they're all competition hold'em, stud, draw poker, fan 10. They're all table game. Horse racing machine. Keno is not.
Need to scroll in the opposite direction so that we go back to where the reference to Arashinko is.
Yeah, I can't tell you what that is, but it doesn't ring a bell.
All right.
But most of those games are table games, but there are things like a horse racing machine. There used to be a horse racing many years ago, which is no longer there. Is trackside there as well? I can't see. But most of those are table games.
All right. If we scroll down a bit further.
Can you make it a bit bigger for me, somebody, please?
And get to video bingo. There's the reference you made to trackside.
Yeah, that's to say, they're not the traditional gaming machines. Bingo and trackside had a different tax rate to the gaming, different, I can't remember, was it retention? No, that's right. The video and the trackside had a different payout ratio, whereas most of the game machines had a 90-cent payout. Bingo and trackside, I think, only had about a 70 or 80% payout. That's all. But most of those are table games, except where you had things like rapid roulette. That's where you had a roulette wheel, and people could sit there around the normal roulette table and play. But in addition, they had cameras on them, and they were able to have stations away from it where people could bet via a terminal, and that's called rapid games. So there was a few of those there, but fundamentally they are table games.
All right. Are you able to identify on the list which, if any, fall within the description of an electronic gaming machine?
Video bingo, the trackside, and I cannot recall what a Shrinko is, but Arashinko is at all. That potentially could be, but the rest of them to me are fundamentally of course, there are the fully automated table games, the video, Vegas Star Blackjack. They are essentially table games with the same odds, but they had to pay a higher tax rate because they were not employing people. So all those particular fully automated table game ones are still fundamentally table games, but they paid a higher tax rate than normal table games.
Mr. Sargent, I'm asking about EGMs. Which of the games that are authorised are EGMs? So I'm trying to ascertain what is a clone of what.
Well, none of those are EGMs per se. Of what you know about, like we call some of those games, which is the poker, etc. But if you look at video bingo, the fully automated table games, they are still a random number generator that generates that result, and trackside are based on random number generators to produce a result. So they are an electronic machine, but they're not classed as the normal game machine that we had on the floor. And I don't know about a Shrinko, I can't answer that. But otherwise, that list to me is mainly table games, which where each had a different payout ratio depending on the rules of the game. But there's no game machines per se that's covering them.
I'm just trying to understand, Mr. Sargent, when you as a member of the GWC are sitting there making a decision about whether or not to approve a new game that's an electronic gaming machine, you said that part of the process is to identify if it's a clone.
Yes.
Say a clone of an authorised game. When you have, on occasion, made that decision that a game is a clone, which of these are you thinking of when you're thinking of, is this a clone of an existing authorised electronic game machine?
I can't see anything there. It must be some other Gazette notice if you was to have an authorised game, but they are fundamentally table games. So all those gaming machines like draw poker that they call them hack this and so forth, they're not listed there. So I don't know what Gazette notice would have declared them to be a gaming machine. Because there's only a definition there on the side, is that you've got fully automated table games defined.
Okay, Mr. Sergeant, I'm going to show you another document. This is document GWC.0001.0007.0068. And you'll see from the front page, it's the authorised rules for a game called Arashinko. The next,
Gosh, is there a date there at all? Because this is a very old machine, I think, isn't it?
the date is 29 August 2019.
19, okay.
And
I don't think that means that was the date it was approved, Mr. Sergeant.
no,
That's just
it's the date of the current rules.
The current rules.
And I just want to show you, the next page is a heading Video Arashinko. And a series of rules. Are you familiar with these rules?
No, not thoroughly. No, I'm not. I can't say I am now. And I'm definitely not familiar with Arashinko. I really can't recall the game.
So is this part of the process that would be undertaken under the delegation to the Chief Casino Officer, is it? Sorry. So the GWC would agree in principle, it looks like a clone, and then the detail goes off to the Chief Casino Officer to implement the changes to the rules. Is that the...
Correct. Now let's say that Arashinko was a new game coming, then those rules would be approved by the Commission.
And what about the changes to the rules?
Rules, if they're a minor change, for some reason, that they could be done under delegation.
What do you mean by a minor change? So look, let's go into definitions and interpretation. There are a series of definitions of what appear to be games. So this is page 4 of the document. So you'll see it begins, there's a game called Amazonia.
Okay.
There's Arashinko, there's Ball Power, various other ones, Cats, Hats, Bats, and so on.
But those cats, bats, that rings a bell as a name. Chocolate Wheel is a game that's all under the heading called Arashinko. Many of those are gaming machines.
Yes, they're gaming machines. And do you understand them to be clones of Arashinko?
No, they would stand there in their own right. They're not clones of Arashinko. You might find that with all those games, there's a commonality of what the rules are. So that whilst the heading says Arashinko for reasons I don't know, the standard rules for each game are basically the same. It's only the certain features of the game which might be slightly different, and that's why they've been defined that way.
So is it your expectation, or would you expect to find, as an authorised game, somewhere in the Gazette, under section 22, a reference to each of the games referred to in that definition?
And yes, you would have to.
As a separate game?
You have to gazette them as per the Act.
And to your knowledge, do you know if that has been done each time a new game EGM has been approved by the GWC?
Sorry, what was that question again, from my knowledge?
Do you know if, from your own knowledge, after the in-principle approval and then the process of delegation to Mr Connolly, there have been a gazettal of new games?
If the game was a different game, because quite often Crown would come and call it a different game, and it had slightly different payout tables because they had a different add-on feature, and it also had different symbols, then it would require some form of gazettal. But I haven't looked at it in detail, so no, it's not something which I've refreshed my mind over for some time.
Sorry, Mr Sergeant, I'm just trying to find an agenda item to show you to try and assist with this part of the examination. If I could ask that we call up GWC point 0002.0016.0126, which is a subject to a non-publication order. And navigate to page 0024. And this is an agenda item referring to a game called the Flintstones Cape Fortune. And if you could scroll down, please, so we go through some of the features and get to page 0026.
So the first, can you go back to the other page? Is that the very first page after the introduction, is it, or is that quite a few pages down?
It goes introduction, current suppliers, which is that page, and then the next page.
So it's telling us that SHL is a ball-based living mechanism for cats, hats, bats, and oink. Yes.
And then the next page, please. And it refers to it being a derivative of Eureka Gold Mine, bottom left. So is it your understanding that the Flintstones Cape Fortune is a clone of Eureka Gold Mine? Is that the way?
That's correct. It's got a new game, a new artwork, and new free game and jackpot bonus features. But fundamentally, the game is the same.
So there should be, according to your evidence, an approved game known as Eureka Gold Mine.
Oh, well, look, you're going to hold me to that. I honestly, without thinking about it, I'm saying yes, but I can't definitely say that's what would have happened. There might have been some other way in which it was promoted, so I wouldn't be held in to make that decision now without getting some time to actually investigate the detail. But that is, as new game, has to be, the rules would have to describe that somewhere to pick up the fact that the new free game and jackpot bonus features have to be incorporated there, and it's got a different name to the other one.
It does have a different name, and you can see some similarities in the visual representation of them.
Yes.
All right. Perhaps
I can't be more helpful, but really I'm only just guessing at this stage.
Perhaps if we could, just going back to something you said earlier about the differences between a poker machine and an electronic game machine, if we could ask that we play a short video of the Flintstones Cape Fortune, which is CRW.700.062.1033.
The name of this game is the Flintstones Cape Fortune. The game incorporates on-screen game rules pages that can be accessed by pressing either the information button on the button panel, information icon on the main game screen, These on-screen game rules include information regarding the bonus features in the game. The initial bet selection process for the game involves 2 steps. 1. Select a number of balls to play. 5 options are offered from a minimum of 5 to a maximum of all 15 available balls. 2. Select a credit value to bet per ball. 5 options are offered with the minimum option always being 1 credit per ball. The other options offered may vary from a minimum of 2 credits to a maximum of 20 credits per ball. After making their bet selections, the player must press a separate play button to commence gameplay. After the player makes bet selections for their first played game, if they wish to play subsequent games utilizing the same bet selections, they can do so by pressing the play button only. When installed on the gaming floor, the game can be configured by Crown to operate at varying approved denominations, ranging from 1 cent to 10 cents. Accordingly, configurable bet values can range from a minimum of 1 cent on a 1 cent game to a maximum of $60 on a 10-cent game. This game is currently configured to operate at a 5 cents denomination, with a maximum bet of $15. The game incorporates 3 jackpot prizes, which are displayed in the EGM top box. The values of the 3 jackpot prizes increment, reflecting a set proportion of the money wagered on the individual EGM. The values of the jackpot prizes offered remain the same regardless of the value of a player's bet. The 3 jackpot prizes offered can be won during the course of playing the game. Crown is unable to confirm the exact minimum speed of play at which the game's software has been developed to operate. Here is a demonstration of how quickly a player may be able to commence subsequent games.
I have some questions to ask you about that particular game, Mr. Sargent. The first is, what are the characteristics of that in your mind distinguish it from a poker machine?
If my memory serves me correctly, that particular game took a couple of meetings to get through because of that very question. That is how fit. But ultimately, it wasn't being, it was just a matter of balls rolling. It had to be 3 or 4. It wasn't like a spinning reel, but I can recall that was the one which did take some time to, I think it got some time to go through. But it's where the distinction is that replication of a spinning reel? And I would say that as a group, as a commission members, we determined not. You might appreciate that with respect to these decisions, and I think I said it either yesterday or this morning, I actually didn't take this one on ourselves. I made sure that this was a real full commission decision because it's a very subjective decision at times as to what constituted a game which is very much like a spinning wheel machine versus the one which is more electronic gaming machine.
If that game simply had reels that spun instead of balls that dropped into position, it would be no different to a poker machine, correct?
Well, but it wouldn't present, the outcome would not be presented as a spinning wheel machine.
What is it?
Sorry.
I just want to ask you, what is it about the spinning reel that you consider to have been the reason for the prohibition on poker machines?
Well, that was the genesis from which they came, the way in which the results were produced. But fundamentally, all the games on a gaming machine, irrespective of whether it's in WA or the eastern states, they are generated on a random number generator, and it's how you present the results. So we've got trackside out at the casino, we've got bingo, we've got electronic game machines, and we've got draw poker, etc. But fundamentally, they're premised around a random number generator. Whereas in days gone by, the poker machine didn't have a random number generator, and relied very much on the electromechanical spinning aspects to generate the outcome. But now they all are generated by a random number generator.
So is the answer then the mechanism for delivery is different to a poker machine in the sense that it's not mechanical, it's electronic?
Well, that's the historic difference.
And there's a visual presentation difference.
It's different. It's not a science, I'm afraid. It's not a science.
Did you turn your mind at all to the what you might term the policy behind the original decision in the legislation to prohibit poker machines?
Well, poker machines were thought to be more addictive, I presume, than what was being placed out at the casino. But in 1985, the Casino Control Committee had to make a call because the legislation said any game that's not on a poker machine. So they had to make the call, well, what games can they approve from machines which are not a poker machine? And at that stage, Burrs would have regarded it on the leading edge because all its machines were the video machines. Didn't have any of the electromechanical machines.
So the decision, if you like, that set on this path was made in the 1980s. Is that your understanding?
I believe so. It was made to the games were played on a video machine, and we still continue to play them on a video machine. Now, I said in my evidence, when the Act was reviewed by Mr. Rodney Chapman, one of the recommendations was to insert a definition of poker machine. Unfortunately, Parliamentary Council couldn't come up with one, so it wasn't inserted.
All right. Thank you, Mr. Sargent. I have a few remaining questions. These are more drawing on your experience as a person involved in regulation of casino for a long period of time. Do you have any knowledge or understanding of internet gambling?
I don't have a lot of knowledge on it because it's not something which we as a regulatory authority have drawn our attention to it, because it's a matter which is governed by the federal legislation, which basically should be precluded. No licensee in Australia can offer internet gaming. So the only gaming that can come into Australia is illegal gaming from outside of Australia. And the Interactive Gambling Act is the one that's designed to stop that. But it's not something that we in WA can control.
So I think you've directed my attention immediately to the gaming aspect, so essentially online casino gaming. I'm talking more generally about internet gambling of a legal nature,
like
betting on horses online and those sorts of things,
betting on horses,
or games of football, or the sorts of advertisements you see.
Yes.
So have you got any appreciation of the extent to which it's online betting is legally available to consumers in Western Australia?
It's legally available. Not only does the WATAV offer a complete service in this regard, but other operators from across Australia can offer their product to Western Australians. It's a legal form of betting.
And do you have any appreciation or understanding of the extent to which, although it's illegal, illegal online gaming is available to consumers in Western Australia?
Did you say illegal or legal?
For instance, if they can go to a website that may be physically located elsewhere and undertake gambling online.
I think Mr. Futrell's now talking about the internet gaming,
internet
illegal activity which you described earlier.
The Interactive Gambling Act covers that. Is that what you're talking about? Okay.
So the extent to which, notwithstanding it's illegal, it's available to consumers and consumers are participating in it.
I understand so, and that there has been some research done on the extent of it. It's probably wider than what I think the federal people want to admit to.
So this is just a matter, an order of magnitude, Mr. Sargent, I'm interested in. Are you aware of the extent to which the licensee of the Perth casino is exposed to competition from either a legitimate form of online gambling or an illegitimate form?
Well, I realise it's subject to competition from a legal form, but that's horse racing and sports betting through our TABs, etc. And our bookmakers can offer internet betting as well. But that to me is just natural competition. But I appreciate that there is illegal gambling, which they're not supposed to participate in, which is the casino style games which come into Australia. And given the remoteness of Western Australia, and given we don't have gaming machines outside the casino, there's probably a greater proportion of it. But for one thing, the state doesn't have the legislative power to control that, and that's very much in the hands of the Commonwealth. I can remember some time ago, one of the lawyers on the commission basically said, in their broad opinion, without getting it detailed, we could probably argue any of that sort of betting is illegal, that is playing with casino-style games. But for that, I probably need about 1.5 million inspectors to live in everybody's home to police it, because it was so difficult to police. But we never did anything in that area because it wasn't something that we had the power over. And the Commonwealth clearly made the decision back in the early 2000s to say no Australian institution shall offer casino-style gambling on the internet.
Mr. Sargent, I'm trying to just get an appreciation of the extent to which that kind of gambling may expose the local licensee to financial risk on the one hand, and also the state revenue in terms of taxation to risk. Do you have any appreciation of the scale of the potential?
No, I don't have appreciation for the scale of it. I don't.
Do you have any view about what, if any, regulatory measures could be taken by a Western Australian authority to mitigate against the risk?
I don't think a West Australian authority can. It's very, very hard for the communication. For instance, it's very hard to stop ads coming into Western Australia which actually would be promoting gaming, because of the way in which certain television products come from a national level. So it's not something which is easily controlled at state board level. So no, I would say we're very much in the Commonwealth sphere to either regulate it or to prohibit it more seriously than what they do. But I don't think that Crown Perth is any awful in that regard. The only difference is Crown Perth enjoys the monopoly. It doesn't have to compete with machines outside the casino. But if you get states like New South Wales, there are a total about 91,000 machines outside the casino. Victoria's got about 27,000 machines outside the casino. I think Queensland might have 41,000 outside the casino.
Well, I want to ask you about a different topic now, also in a similar sense related to risks facing regulation in Western Australia. Do you have any knowledge or understanding of the availability of cryptocurrencies or digital currencies?
No, I'm afraid I don't. I really know nothing about those currencies.
Have they come across your desk at all as a member of the GWC?
No, and they never came across my desk as a DG either. I really don't know anything about those currencies. Okay,
now, there's one last area of interest, Mr. Sargent, which it concerns, and if you can't recall, I'll try and refresh you from a memory from a document. A proposal of Crown some years ago in 2009 introduced a system called the ITG Advantage or IGT Advantage system in connection with its loyalty program.
The name rings a bell, and that's ITG rings a bell, yeah.
I want to put a couple of things to you about the way in which that that program operated, and if you don't know, I'll try and refresh me from the document, but there's a loyalty program whereby patrons of Crown Casino can redeem loyalty points to utilise in electronic gaming machines. Are you aware of that?
Yes.
And the way in which the system operates is they redeem to redeem the loyalty points, they must in fact use their own funds initially to place the bet. The game then plays, and then at the end of the game, the player, whether they win or lose, is credited the value of the bet from the loyalty program points. Is that your understanding of the system?
That does ring a bell, yes.
And do you recall there being a question asked around the extent to which redeeming of the loyalty points in that way was to be included in the revenue from gambling for the purpose of calculating state tax?
My recollection is no.
It wasn't considered to be part of?
It was not considered to be available because bringing to my way of thinking, bringing those credits in was just a way of which giving more credits. That was my understanding, no. Similarly, when they had some of their prizes were motorbikes or cars, etc., the Commission made a determination that they had to actually include in the as a prize for the cost of the car, not the market value of the car. So there had to be some evidence of what it is. My understanding, no, that particular order was not to be a deduction.
So
as a cost against the revenue.
Just in terms of your recollection, is it something that was, to your recollection, brought or considered by the GWC and a decision made that is not included in the revenue?
I couldn't say, but in my mind, that was not the intention. That was just a matter of giving somebody some free games.
Okay. Mate, please, question. Those are my questions.
Thank you, Mr. Futra. Now, does Council, well, Mr. Garros has pointed the finger at you, Ms. Seward. Do you feel targeted there? Yes.
I do a bit, but I'll give it a go anyway.
Something to do with bullying, I think.
So I'll just... Mr. Sargent, can you see and hear me?
Yes.
My name is Seward and I act for the department. I just wanted to ask you a few questions. Firstly, about the Problem Gambling Support Services Committee.
Yes.
During your time on the committee, there would be agenda papers before the meetings.
Yes.
Is that correct? Yes.
Yes.
And then there would be minutes kept of those meetings as well.
Yes.
And
Yes.
yes. And as part of those agenda papers, on occasion would there be reports prepared detailing the work which had been done under the various programs that were funded?
Yes.
And they could be sometimes in the form of annual reports or quarterly reports?
Well, very much so quarterly reports, very much quarterly reports.
Okay.
Or half year, whatever, how often we met, but there were reports prepared, particularly by the service providers for the counselling services, that is the telephone, internet and the face-to-face counselling.
So that's the one run by Centrecare in particular?
Centrecare was the face-to-face, yes.
Okay. So if we review those agenda papers, we'll find those reports detailing the work that had been done under the contracts.
I hope so, that they're there, I hope so, yes.
You were also shown a copy of the 2015 paper, which I don't need you to see, where Mr. Connolly proposed the removal of the inspectors
Yes.
from the casino. Just wish to establish...
Sorry, it wasn't the removal of inspectors. People keep saying that. The inspectors were still going there to work.
Yes. Thank you. Yes, you anticipated my question. The inspectors would still go to the casino to undertake some of their audits and inspections.
Yes.
What changed is there was not an inspector who was rostered to spend their entire shift at the casino.
Well, before they used to actually go there and start their shift and finish their shift at the casino. This time they go into the office and in the department and start their shift and be allocated out from there.
Okay. And prior to 2015 and the change, immediately prior to that, we've heard evidence that there were 20.5 hours was spent at the casino.
That was the intention, yes.
Yes. And is it the case that that was 2 shifts over the 24-hour period?
Yes.
And in each shift, there was 1 inspector appointed?
Well, there could be more, but there definitely would be 1, definitely 1.
Okay, thank you. No further questions, thank you.
Thank you, Ms Seward. Mr Malone.
Thank you, Commissioner. Mr Sargent, can you see and hear me?
Yes, yes,
My name is Malone. I act on behalf of Mr Connolly.
yes.
I just want to take you back to the early part of 2017, if we may, just at the start. In answer to some questions from council assisting today and yesterday, you've used the word "I cannot recall" quite a bit. I just want to test your awareness of the conversations you had with Mr Connolly in early 2017. I imagine you cannot recall each and every conversation you had with him during, say, January 2017 to the time you ended being Director General. Would that be right?
Yes.
Thank you. I then want to turn to some evidence you gave this morning in relation to council assisting's question. In relation to your trip to Melbourne in 2012. Do you remember giving that evidence this morning?
Yes, the only thing I questioned there, whether ultimately Crown was charged for that.
Yes.
That was 2012. Whilst it shows that it was paid for, I can't recall that happening, and I didn't prepare the report.
Yes, sorry, Mr Sargent, I'll stop you there. Yes, I'm not going to ask you about the content of that trip. Just in answer to one of the questions put to you by council assisting, you used the phrase, "first knowledge I have." Now, I understand what you meant by that was to say you cannot recollect. That is, it's not that you don't have knowledge of that trip, it's that you don't have a recollection of that trip. Would that be right?
That's correct. It's the first time I'd seen it, so I can't recollect that trip, yes.
Yes. So you draw a distinction there, therefore, between the word knowledge and the word recollection.
Yeah, I should have used the word recollection. I don't recall that.
Yes. So then, if we turn to paragraph 64 of your most recent witness statement, if you've got that in front of you. This is in answer to question 26 about the complaints raised by a compliance inspector.
Yeah.
Now, in the context that we've just gone through, that is, you cannot remember every conversation you had with Mr Connolly in early 2017. And the difference between the word knowledge and recollection, your answer there that I have no knowledge, would it be fairer to say that you just don't have a recollection? That is, there may or may not have been a conversation, but you don't have a positive recollection either way.
I would say that's fair.
Yes. And would you say that's fair in relation to...
Can I just add, what happened when we were down in the Hyatt Centre, our offices were next to one another.
Yes.
When we moved up to there, our offices were quite well away from each other, so we didn't have the opportunity to actually sort of pass notes as much as we used to. And I didn't see Mr Connolly anywhere as much when I was in that situation in the new offices versus when I was down at the Hyatt Centre.
Thank you. Thank you for that qualification, but I understand you've taken... Your answer there is that is a fair assumption to my question. So then if we turn to paragraph 65, that is again...
65 or 55?
65, sorry, just the next paragraph along, on the next page. You again use the phrase, I have no knowledge. Would it be fairer to say there that you have no recollection? That is, it may or it may not have occurred, but you just have no positive recollection either way.
I think in the case of Ice Track, I would stick closer to the no knowledge.
Thank you, Mr Sargent. And that is to say that you have a positive recollection of no conversations during that time? In
that case, yes.
Yes. In circumstances where you cannot recall each conversation you had with Mr Connolly? I
can't, but I still am very confident I had no knowledge of that.
Yes, understood. Thank you, Mr Sargent. Then just one final area, You gave evidence in your witness statements and also to counsel assisting today in relation to your awareness of friendships Mr Connolly had with certain individuals. Mr Connolly, and to be fair to you, I'm putting this to you, Mr Sargent, to be fair to you, you do not have to agree with me in any way if you don't. Mr Connolly's given evidence to this commission that he did in fact tell you about the friendships he had with Mr Murray and Mr Hume, at least. And Mr Ord has given evidence to the commission that in light of media allegations, if you will, that arose early this year about the friendships Mr Connolly had with personnel at Crown, he had a conversation with you. And in that conversation, he confirmed with you that you were aware and that those friendships had been noted whilst you were Director General at the time. In the context of that evidence being given, does that refresh your memory that you were told by Mr Connolly, or do you still have no recollection of being told?
Or about
The only
what?
knowledge-
Sorry, just before you answer, Mr Sargent, can we just,
Yes.
I just want to clarify what it is you say
Thank
he
you,
was
Mr
told.
Diggins. Yes, specifically in relation to his friendships with Mr Murray and Mr Hume.
I've acknowledged that I knew about the fishing for the friendship with Mr Murray. I accept that, but definitely not Mr Connolly and Mr Hume, above, beyond them working colleagues. When the issue became a media matter in relation to Mr Connolly, Mr Ord did ring me. The conversation was only about Mr Murray, because that was the only person that Mr Connolly at that stage had declared to the Commission, his friendship with Mr Murray, because he came to a meeting.
Yes.
I did not speak to Mr Ord about anybody other than Mr Murray.
Thank you, Mr Sargent. No further questions. Thank you.
Thank you, Mr Murray. Ms Young?
No, thank you, Commissioner.
Mr Garros?
Thank you, Commissioner. Mr Sargent, my name is Garris. I appear for the Crown Companies. I just have a small number of topics that I want to address with you, and we'll start with some documents. Can I have two documents up side by side on the screen, please? It's GWC.0002.0016.0001. Can we keep these to the personal screens, please? And can we go, just before we move from that, Mr Sargent, you'll recall these are the minutes that Mr Futrell took you to, the meeting of 23 February 2009. And can we also then have up next...
February 2009, was it?
Yes, 23 February 2009. And can we also bring up Mr Ord's first statement, DLG.0001.0002.0001. Thank you. Now, with the document on the left, can we please move forward to page 0337? Thank you. And with Mr Ord's statement, can we move forward to page 0022, please? Mr Sargent, you'll recall Mr Futrell took you to the document on the left, which of course relates to the removal of the junket approval process. And there were two main reasons that are cited. So I'm not sure if you can read those or recall them, but...
Excuse me, you talked about 2009. This is
Yes.
2010 is the year you're talking about, aren't you?
This is, yeah, you're quite right. It's an attachment to the document which I took you to at the start, which had 2009 on it, but this relates to the removal of the junket.
Yes, that's fine, yes.
Thank you. It's just been produced to the Commission as a bundle of documents. But you'll see the second bullet point being the second of the reasons advanced by Crown, being the imposition of economic costs, which are in substance creating competitive difficulties in a field that is the international commission business, which is extremely competitive. Now I'll ask the operator please to just move forward to the next page. and from halfway down the sentence, beginning with the casino operator's assertion. Can you just magnify that through to the bottom of the page, please? So I'll just allow you to quickly read that, Mr. Sargent, but it gives explanation in relation to the question concerning economic costs.
That was the National Competition Policy Review, wasn't it? I think that one.
That's correct, yes. Have you
Yes.
finished reading that section? And if we can just go to the next page as well, please. And can we just
And this document, who prepared this document? Was this for whom?
so this was a commission document. This is part of the
On the right.
recommendation.
No, not on the right,
the-
the one on the left.
If we just magnify the document on the left again, the first three paragraphs, thank you. So I'll just let you read the balance of that material. I think the question you may have been asking is this directly commission papers, or is this quoting from something? I think the answer is this relates to matters opined on by the Productivity Commission.
That's right. This was Mr. Toyne worked on the National Competition Policy with an economist we retained. Mr. Toyne, the only one who would have known the availability of this information, but I can recall that's when I familiarised myself with the 2010 decision. It was very much based on the National Competition Policy Review, as well as the police matters. But this was a big part of it. Yeah, I understand. That is basically government commission sort of game commission material.
Sorry, can I just stop and clarify this as to whether what is being quoted here is Mr. Toyne, or what is being quoted here is the Productivity Commission? Because it's not entirely clear to me from looking at the commencement of the quote. Mr.
Do you want me to
Gavin,
answer that commission, or if it was led at council?
No, well, if you can answer it, Mr. Sargent.
I think it is a quote by Mr. Toyne's paper that does come citing it from the National Competition Policy Review. That's my understanding of it.
Thank you. And now, if we can just go to remove the magnification and then do the same thing with Mr. Ord's statement at paragraphs 71 and 72. You'll see here, this is an extract from Mr. Ord's witness statement in this commission with not dissimilar language that you just read from this paper. Now, yesterday, while you were discussing the removal of the junket approval process in 2010, I understood you to say that there were some matters in relation to government red tape. Now, I understood you to be referring to the removal of red tape. Were you referring by that phrase to the implementation of the National Competition Policy as being one of the drivers behind the removal of the junket approval process?
No, when I used the word red tape, there was a push within government about red tape reduction. But when this matter became an issue for the Commission, and I think I said somewhere either yesterday about the early discussions of it, and Mr. Mark Beecroft had reminded me about one of the main drivers was the police side of it. Only as a result of the Mr. Toyne's evidence that I went back and refreshed my memory to see that a big part of the decision in 2010 was based on the National Competition Policy Review decision. So it was an integral part of the decision back in 2010.
Thank you. Can we just magnify, while we're on this page, the entirety of paragraph 74 of Mr. Ord's statement, which continues over to the following page? This is a slightly different topic, Mr. Sargent, but it's convenient to deal with it while we're here on this page. I just want you to read paragraph 74 of Mr. Ord's statement and let me know whether you agree or disagree with that statement.
He's saying he's using the word incorrect view as his performance because of the position taken that I presume he means not to be responsible for money laundering, etc.
That's how I understand it.
Yes, I understand that. That's what Mr. Ord would be referring to.
And do you agree with that as a statement? Does that also reflect your understanding of the Commission?
I don't like to use the word incorrect view. I think it was a view that they're taken, that wasn't a matter of urgently to take for the Commission, but whether the word incorrect puts some sort of different connotation to it. But principally, it was because of the view that money laundering was one which was undertaken by other agencies and the for police responsibility for illegal activities, then that's why some of the investigations were delayed by the Gaming Wagering Commission.
And is that the understanding that you had prior to the Bergen inquiry?
Yes.
Thank you. We'll just move on to the issue concerning the dedicated inspectors. Can we just bring up Mr. Sargent's second statement, GWC.003.0019.0019.001, and can we go to page .0015? Now, paragraph 36, Mr. Sargent, Mr. Futrell took you to this passage before and you've listed 4 factors which you say weighed in favour of the GWC's decision to remove the dedicated inspectorial presence at the casino. By the last factor, which speaks about salary limits, were you referring to what you otherwise described in this statement as the workforce renewal policy implemented by Treasury in 2015?
That was the fundamental behind it, yes.
And can we please go to page .0009?
What paragraph is that?
It's paragraph 21, Mr. Sargent. So paragraph 20, just the first page is fine, thanks. At paragraph 21, you've made express reference to that policy, and you've confirmed that's in substance, the policy that underpinned that last factor you referred to in paragraph 36. Now, in your evidence in relation to this matter, when you were being questioned by Mr. Futrell, you also referred to the question of, or the implementation of redundancies. You've referred to that in this third sentence, and so that is the redundancies that you were referring to when you gave that earlier evidence?
Yes.
And this was one of the key factors, was it, behind the change to the dedicated inspectors?
I don't think the redundancy program would have been.
Sorry, I'll clarify. Just the salary limitations as a result of this workforce renewal policy.
We were very conscious of that we had time to work towards making sure that we could achieve those limits, and this was just part of the overall strategy.
Thank you. And I won't take you back to paragraph 37, although you're most welcome to look at it. You do speak to the new surveillance more than compensating for the reduced presence of the inspectors. Is it fair to say that you consider the electronic surveillance at Crown to be superior to the old system of inspection?
I do, and I wouldn't have done it unless we thought so. I wouldn't have supported the policy that Mr. Connolly was promoting without. Yes, I do.
Thank you. Now, we're going to move on to the topic of the Riverbank account. Can we bring up Mr Sargent's first statements, GWC.003.002.001, and go to page 18, please.
Is this the one back in May, or is this the one you're talking about here?
This will be your first statement, which was May, correct, Mr Sargent? And can we go to page 18 and can we just expand paragraph 80, please? So you've expressed in paragraph 80, Mr Sargent, that specifically in relation to money laundering risks, you don't believe that it was, or indeed should be, a responsibility of the GWC. And am I correct in saying that historically you understood the GWC's audits of the casino's gaming accounts, when you refer to for the purpose of revenue oversight, is that in substance ensuring that the correct casino tax is paid?
Yes. Yes.
And do you recall how regularly those audits were carried out?
Oh, if I remember, it was monthly. We were getting monthly reports, audits of the revenue.
Thank you. Now, you also say that, at least historically, you consider that the GWC and the department did not possess skills or resources necessary to conduct sophisticated financial analysis. That's in paragraph 80. Can you just elaborate on what you mean by sophisticated financial analysis?
Well, if you look at what analysis has been done by Crown since with relation to the Bergen inquiry, I can assure you the skill base of my inspector, even I didn't have that sort of skill base to do that sort of analysis.
Thank you. I'll just bring up another document then, CRW.513.024.6387. And sorry, can we confine that to the personal screen, please? Now, Mr Sargent, Mr Futrell took you to this letter before. It was received, or I should say it's dated, but received around the time of 23 August 2019. In particular, I'll just note it's addressed to Miss Perry. Did you have a close relationship with Miss Perry?
No.
Okay, and then can I just have the document?
Bearing in mind that I was only a ordinary member of the commission and I wasn't a full-time staff member.
Thank you. Now, just pause for a moment. Paragraph 2 makes reference to direction 4.1c, and Mr Futrell took you to that particular direction earlier today, which talked about the requirement to provide bank reconciliations. Then can we just move the document up, please, and so that we can see the passage that begins with "as discussed with Mr Hume." Thank you. And can we just magnify for Mr Sargent those two last paragraphs? So if I understood your evidence correctly before, Mr Sargent, you were aware that, well, you became aware of the Riverbank account in 2019 around
August 2019, when Mr Preston gave a presentation to the valuation late August.
Thank you. Now, I just want to direct your attention to what's said in this particular passage, where Crown has informed the department that there had been an oversight in relation to the provision of information regarding the bank accounts. And you'll see if you read it that it explains that Crown enclosed with this letter not just the reconciliation but bank statements for the relevant accounts for the 12-month period from 1 July 2018 to 30 June 2019, and it's marked as attachment 5. Now, I'll just ask the operator, can we move forward please to page 6444? So you'll see there on the right-hand side at the bottom, Mr. Sargent, it is attachment 5. And in the bottom half of the table, you'll see that the Riverbank Investments account is identified. 4 different accounts, and you'll see that there are 4 different currencies. Then if we can just move forward, please, to page 6694. That's the reconciliation in relation to Riverbank Investments. And if we move forward one page again, please, to 6695, you'll see what starts here at this page, and I won't take you to all of them, but this is the bank statement for the Riverbank Investments accounts for the Australian dollar currency, and it's for the period 1 July 2018 to 31 July 2018. For the purposes of the transcript, the other currencies begin at .6731, .6736 and .6760, and the statements are provided for that 12-month period in relation to all 4 of the currencies. Now, what I understand, what I want to ask you, Mr. Sargent, is whether you are aware that these statements had been provided to the department around this time.
How could I? I wasn't a member. I had retired in March of 2018.
But you were on the commission at the time.
Yeah, but this is departmental information. It didn't come to the commission.
So that's what I wanted to get to. So, to your knowledge, this material was not provided to the GWC? Definitely
not provided. From my perspective, what was the date of the memo to Ms. Perry? Was it October?
This particular letter was 23 August 2009.
Oh, 23 August. So it was before Mr. Preston came. No, I don't recall seeing any of that sort of detail. There's a lot of detail which never come across the Gaming Commission agenda.
Thank you. I'll ask the question, but it's obvious what your answer will be. So you don't know if any analysis was performed on these particular bank statements then?
No, I do not, no.
Thank you. Can we then go to another document, just on the personal screens again, please? GWC.0001.0007.0360. Now, what you're seeing here, Mr. Sargent, is correspondence the following month on 9 September 2019, again to Ms. Perry, and you'll see reference to the provision of accounts. And can we just move forward, please, to page 0024? So once again, this attachment you'll see in the bottom half of the table refers to the Riverbank Investments account and the 4 currencies. And if we move forward, please, to page 0048. And so the bank statements have again been provided in this instance for August, and it's all 4 of the currencies. I won't take you through them, but I'll ask you the question, do you recall ever seeing these statements for this month?
That didn't come to the commission, no.
Thank you. One more that I'll just put up on screen for the moment. It's document GWC.0001.0007.30363. And just on the personal screens again, please. this is the following month, so October, 14 October 2019. Again, to the department. And if we can move forward, please, to page 0024. It's that same cover sheet for the attachments identifying the 4 Riverbank investment currency accounts. And then if we can move forward, please, to 0043. And again, this is now the statement for September, the Australian dollar currency, and the statements for the other 3 currencies are also provided. I'll just ask again, do you recall ever seeing these statements for September 2019?
No.
Thank you.
No.
Thank you. Now, I can just say for the record, similar correspondence was sent to the department dated 8 November 2019, and that is GWC.0007.0365, again providing the attachment at page 25 and the reconciliation and bank statements from page 47 onwards. They don't need to be shown. Then December, Commissioners, the 5th of December, document GWC.0001.0007.0367, correspondence dated 5 December 2019, providing the table that's common to these documents at page 25 and the reconciliation and bank statements from page 47 onwards. Then I will have you bring this one up. It's GWC.0001.0007.0370. And what you'll see now, Mr. Sargent, is a letter, the same type of letter to the department dated 6 January 2020. Again, I don't need you to move forward to the later pages, but the attachment common to these documents with the table is at page 26, and the reconciliation and bank statements start at page 47. But I just want to draw to your attention the numbered paragraph 3. Now, in your evidence earlier today, you said that the Commission was never notified that the Riverbank investment accounts had been closed. I just ask you to read the closing sentence in numbered paragraph 3, which did in fact notify the department that the account had been closed. Is it the case that that information was never conveyed to the Commission?
No, not formally. I did indicate I knew it had been closed, but I had made inquiries myself. But I can't recall it being formally advised the Commission that it had been closed, but I was aware it had been.
Thank you. Now, can we bring up document CRW.518.002.3444? Mr. Sargent, these are the slides to a presentation that was given to the Commission on 27 October 2020. According to the minutes, you attended that meeting via Teams. Do you recall?
That's correct. That's correct.
And if we can just move forward to page 3445, please. So I'll just let you read the first 2 bullet points, but clearly they relate to the ILGA, or an update in relation to the ILGA inquiry, and importantly a recap on immediate controls to improve compliance. And then can we move forward please to page 3448? So I'll just allow you to read this, Mr. Sergeant, but you can see obviously it's specifically in relation to the immediate controls, identifying shortcomings that had arisen through the Irriga inquiry, and Crown acknowledges the seriousness of the issues, and then the sub-bullet points, a matter which you had presumably by now become aware of, the closure of the Riverbank accounts in December 2019. Can I just pause there? Did you first learn of the closure at this presentation or before?
No, I think I would have known earlier than that, because I was trying to find some information about had the department received any formal notice about the opening of the accounts. And they'd gone back to about 2012 and still haven't found anything to informally advise the department the accounts have been opened. So through that process, I became aware of the fact that the account had been closed before this.
Thank you. And then the further bullet points, and the next one is particularly significant for what I want to discuss with you. So it explained that Crown had issued a direction to the cage that under no circumstances should transactions be aggregated in psycho. And then I'll just let you read the next two bullet points about the...
Can someone make it a little bit bigger for me, please?
Just make it like that, please. Thanks.
Thank you.
Is that better, Mr. Sergeant?
Yes.
Thank you.
Okay, yes, I read that.
So do you recall the discussions around these topics during that presentation?
I don't think there was much discussion at all. Who actually presented it? Was this the CEO? I can't recall who presented it. Can you tell me that?
Do you have a recollection of who presented it or not?
No, I don't, I'm afraid, because I think that was the time that Mr. Connolly announced his relationship with Mr. Maris to the Commission. Was it one of the CEO? I don't think it was the chair. It doesn't really matter, but I just might put a better context, but as to who presented.
So you don't have a very clear recollection of the presentation itself?
No, I don't at this stage. No, because a lot of it was motherhood statements to some extent, but yeah, so I don't recall who it was. We had a number of presentations in that period of time leading up to the December.
Thank you. I'll bring up a document just to assist you. It's GWC.002.0016.0333. So these are the minutes in relation to that meeting. Does that assist your recollection at all, or are there particular items I can direct?
Can you magnify it a bit for me, please? It doesn't tell me who was presenting the report, though.
Can we just move through the pages, please, on screen?
Normally it's put list attendees there.
If I can try and move things along, I've got a letter here which is GWC.0010.0010.0003, which is a letter from Crown, 14 December 2020 to Mr. Ord, and it says, we refer to the past presentation of Mr. Ken Barton, together with Mr. Lonnie Bossy and Mr. Claude Murray, to the Gaming and Wagering Commission of Western Australia on 27 October 2020. Does that ring any bells?
Thank you. Yes, I thought it was Mr. I wasn't too sure that Mr. Coonan had come across, but it was Mr. Barton. Thank you,
Thank you, Commissioner. Can I just direct your attention then, Mr. Sergeant, to the page on screen, item 5.2, and just let
Yes, can you magnify it again? Yes.
Of course. So you'll see that meeting that obviously accords with the matters that Commissioner Jenkins just informed you of. And you'll see that the meeting, it appears, commenced at 9:08, or at least the attendance by those presenters at 9:08, and that they left at 10:27.
Okay, yes.
So the meeting lasted, according to these minutes, over an hour. Does that accord with your recollection?
But it was a long meeting. I can recall that at the time, but that generally accords with what happened, yes.
Thank you. Now, can we have another document up on screen? Again, just the personal screens, please. It's GWC.0004.0015.0001. I'll have parts of this magnified for you, Mr. Sergeant, but this is a letter from Crown to Mr. Ord on 14 December 2020. Now, if we could just magnify the introduction, first of all, the introductory paragraph. So you'll see in the introductory paragraph, Mr. Sergeant, there is a reference to the presentation that was provided on 27 October 2020, being the very presentation material that I just took you to.
Okay, yes.
And then as you work your way down from the second paragraph onwards, you'll see that Crown essentially thanks the Commission for providing the opportunity to address the issues identified through the course of the ILGA inquiry. Importantly, and I'll take you to it in a moment, they attach Annexure A to this letter, which they say formally advises the Commission of the current status of the ILGA inquiry. The second bullet point, the controls that Crown had implemented in response to the inquiry, and it also talks about the significant reforms that are being implemented. Just pause there. Do you recall receiving or reading this letter at that time or subsequently?
I can recall whether that was a letter, but I can recall that they did follow it up with the detail from the October session.
Okay, and so if we can just go through past the second page and just scroll through and onto Annexure A, which is page 3, please. So this is the Annexure A that was referred to on that first page. It commences at the third page of the letter. Can we move the page up to the second heading, and it should be entitled ILGA Inquiry Immediate Controls, and just make that as large as possible, thank you. So you'll see in relation to the immediate controls, again, reference is made to the presentation, and Crown goes on to explain at the bottom of the first paragraph that they have implemented controls to immediately mitigate against future incidents in a not dissimilar way to what was set out in the October presentation. You'll see that the first paragraph A identifies the closure of the accounts, which was historical. Then B, they talk about the direction to prohibit aggregation in psycho in relation to the accounts. In that same paragraph B, they give notice of a new bank statement monitoring policy, which is enclosed as attachment 1. Then in paragraph C, they give notice of the direction prohibiting all cash deposits, and they provide a copy of that as attachment 2 to this letter. Over the page, and we'll get to item D in a minute. Can we just expand that, please? And so you'll see the third of the significant policies implemented is a policy prohibiting third-party transfers, a copy of which is enclosed in that letter as attachment 3. And then can we just move up the page, please, to around the middle of the page with the paragraph commencing with importantly. And can we just expand that? So Crown goes on to talk about the fact that importantly in respect of the controls listed in 8E, and I've obviously taken you through A to D, Crown has submitted proposed amendments to the casino manual operations. And in the next paragraph, and can we just magnify the next one, please?
Mr. Garros, is there a question?
There will be in a moment, Commissioner. I'm just making sure that the witness is familiar with this material before I ask those questions. Now, here the Crown has identified the fact that they have obtained reports from Grant Thornton and Initialism, which were enclosed with this letter concerning the Riverbank account. So I want to just direct your attention in particular to the third bullet point, which identifies the fact that the Initialism report in relation to its review regarding indications of money laundering based on Grant Thornton's analysis of the accounts was part of those materials. So you indicated you had read this letter at some point in time. Do you recall when that was?
No, I don't, but I have read it and I remember going through those reports. I wouldn't say I fully understood them, but I can recall those reports.
But you can't recall precisely when you went through it?
No.
Mr. Garros, can I just stop you there, because my understanding is we have to have a 10-minute break for the transcribers if we're to go beyond 4 o'clock, so we might take that break now.
Of course.
Mr. Sargent, as I've said, is that the transcribers require a 10-minute break if we're to go beyond 4 o'clock, and we're not going to be able to finish before then. So whilst I do hope we'll conclude shortly for your sake, given the time there, we will require a 10-minute break now.
Okay.
So we will adjourn for 10 minutes.
rise.
Thank you. Please be seated. Yes, Mr. Garros.
Thank you, Commissioner. Mr. Sergeant, following the receipt of that letter then, dated 14 December 2020, to your knowledge, did anyone at the department or the GWC review the policies and directions that were enclosed with that letter, or the initialism or Grant Thornton reports?
Not that I'm aware of, but the commission members wouldn't do it, so it'd be matter for the department. I'm not aware of a report coming back to say that it had been reviewed. No.
Do you know if anyone within the commission or the department subsequently raised any queries with Crown about the substance of that letter and the attachments?
Not that I'm aware of, but I think at the December meeting we had another presentation at some stage, but no, I can't recall. Definitely, I can't recall.
Do you know if any of these issues, as identified in that letter, were placed on any subsequent meeting agendas of the Commission?
Not specifically, no.
Now, coming back to whether or not the material itself was reviewed or analysed, and the view you expressed previously as set out in paragraph 80 of your first statement, is it the case that the department and the commission would not have actually had the skills in-house to analyse any of this material?
Well, as again, the commission wouldn't have been able to do it. It doesn't employ staff. We relied on the department, and the department would not have had the skills to do that.
Thank you. Now, I just want to move on to the last topic, and I'll be very brief. Are you aware of the suggestion that's been made by counsel assisting in this commission that the GWC was potentially the subject of, and the phrase that was used is regulatory capture?
I've read it, but it hasn't come specific to me. There's no questions asked about that.
Do you understand the meaning of that phrase?
Yes, I do.
Can I just ask you this then? During your tenure as Director General or a member of the GWC, did you ever personally give favourable treatment to Crown?
No.
Are you aware of anyone else within the Commission or the Department giving favourable treatment to Crown?
No.
Thank you, Mr. Sergeant. Commissioners, I have no further questions.
Thank you, Mr. Garros. No other counsel. And Mr. Murphy?
No, thank you, Commissioner.
Thank you. Mr. Sergeant, I have a few matters to ask you about. First, in relation to the removal of multi-line betting from the policy, the EGM policy.
Yes.
Do I understand your evidence to be that whilst you were on the GWC, you do not recall the GWC approving the removal of the prohibition from the policy?
That is correct. Although the agenda paper referred to it, the agenda paper wasn't actually approved per se. So no, it wasn't approved.
So when was the first time you heard that it had been removed from the policy?
Only a result of preparing my statements for this.
Now, I think another witness has drawn the distinction between the appendix and the policy in terms of how they would be amended. What did you understand about the EGM policy? Is that a GWC policy or a departmental policy?
It would have been issued as a GWC policy, but the department would have prepared it. And because the Commission only approved those two other items, there was no specific authority for them to amend the policy.
So the point I'm getting to is who had the authority to amend the EGM policy?
Only the commission. That was not delegated at all. It was a commission decision.
Thank you. In relation to the audits, and I just apologise if I asked you this on the previous occasion, but in terms of the audit and inspection program, is there any reason why the GWC did not audit the responsible service of gambling framework and program of the Perth Casino?
I think I admitted in my evidence, I think that's something we could have done a better job on. I think we weren't very proactive in that area. Just said, no, we didn't.
Whilst you were on the GWC, and start again. Do you recall, whilst you were on the GWC, whether the GWC authorised the Pearl Room at the Perth Casino to open during any COVID lockdown period in Perth?
No, I'm not. I'm not aware that we had specifically authorised that activity.
Was there any discussion of you doing that or not?
I can't recall any discussion. From my perspective, the casino was closed.
Either as the Director General or a member of the GWC, did you have any understanding of the banknote acceptor limit for electronic gaming machines, what it was?
I understood it to most of the machines was about $100. $100 note.
And did you understand that the fully automatic table games had a different banknote acceptor limit?
No, Commissioner, I didn't. I thought it was a common limit of $100 at a time.
Thank you for that. We heard evidence from Mr. Ord, who said that there was an officer in the department who was responsible for responsible service of gaming and or harm minimisation, I suppose, regulation within the department. Mr. Connolly said he didn't know of any such person. I just thought I'd cover off and see if you were aware of any such person.
I concur with Mr. Connolly's evidence. I don't recall that.
Thank you. In respect of the casino tax revenue and the questions you were asked by Mr. Futrell, I wanted to make sure that we're all on the same page about that. The issue I have, or that I want to speak to you about, is not whether the casino deducted the value of certain things from their revenue, but actually whether they included the value of the Crown rewards points, which were then converted to gaming credits as part of their revenue. Now,
I wouldn't have thought so. I don't recall it, but given that the most revenue is centred around the cage activities, it's basically money in as for gambling, less money paid out as prizes. I'd be very surprised it would have come in, but I from my perspective, no, it wasn't included.
Right. And do you ever recall it being raised with the department or the GWC by Crown, and just let me add something to that, and Crown telling the department and or GWC that it was not going to include it as part of their revenue?
All I can say is it was never raised with me, and it wasn't raised in the Gaming Wagering Commission meeting. Whether it was raised at a departmental officer level, I can't confirm that. But from my perspective, no.
So do I understand from what you are saying is that you cannot recall it ever being an issue at all?
No, not an issue which required attention.
Thank you. Whilst you were on the GWC, was there ever an occasion where the casino sought probity approval for a new director, either at the Burswood entity level or the corporate Crown corporate level?
That they had to have key employee license of some of those people. They would have applied.
So a director, it would be.
A director.
It would be in the sense that they would need a key personnel licence at the director level.
At particularly the Burswood Limited, I'm not sure whether there was a few. Some of them at the Crown level may not have been, but I know we had some of the key like chair and etc. But definitely at the Burswood Limited, they would have all had to have had key employee licences.
And did those applications have to be determined by the GWC, or could they be determined at the departmental level or by delegation at the departmental level?
It would have been by delegation at the departmental level. I can't recall them coming to the Commission, so they must have been all in order. So when I say that from a probity point of view, I think yes, I'm wrong, under the agreement attached to the Casino Burswood Island agreement, it had to be approved by the Commission, members of the Burswood Limited, but it didn't require the same approval for people from the Crown Holding Company. So Burswood, they didn't need to, the actual licence didn't have to come to the Commission, but they had to be approved by the Commission under the agreement attached to the Casino Burswood Island Agreement Act. There's a requirement for all the directors to be approved by the Commission.
So what I wanted to know was the process for that, whether such applications came to the GWC for approval or whether they were done under delegation or...
No, the approval for them to be appointed to the board of Burswood Limited would have definitely come to the Commission, but it wasn't a private, like a probity approval application. That would have been done under delegation by the departmental officers. So they would have got their key employee licence approved, and then before they became a director, they would have had to have come to the Commission, and the report would have indicated that they've got the key employee licence. Okay, it's now a matter of approving them under the agreement attached to the schedule to the Casino Burswood Island Agreement Act, the state agreement.
And in respect of a director of the Crown Resorts Board, for example, who was not going to be a director of Burswood, one of the Burswood entities, was any kind of probity or key personnel licence required for that?
Yes, it would have been that, but that wouldn't have come to the Commission. As long as it was all clean, and it would have been done under delegation by the departmental licensing officers.
And when you were Director General, did any of those sorts of applications get dealt with by the department that you can recall?
Oh, they would have been dealt with by the department, particularly in 2004 when the takeover occurred. That there would have been a number of approvals required for key employee licences, and that would have been handled by the licensing officers.
Was there any kind of policy or procedure for the sorts of checks that had to be done when such an application was received?
Well, there's a standard application form. Now, sometimes there were elements of those forms which didn't have to be completed if they were licensed in another jurisdiction in Australia, but there are some fundamental principles, and they would have been referred to the police for probity approvals. But there was a form they had to fill out.
In respect of the 2017 AUSTRAC Casino Junket report, when did you become aware that AUSTRAC concluded in that report that some state regulators over-relied on immigration and border force vetting to ensure that junket operators were not infiltrated by criminals or conducted by criminals?
I only came aware of it through preparing my evidence statements.
You were asked about a coffee meeting with Mr. Felsted on the 27th of October 2014. You said that you didn't think that Mr. Felsted spoke to you about reduction in the ICB tax rate. Do you recall what operational matter was current at that time, which would have been the subject of the coffee meeting with Mr. Felsted?
No, I can't, Commissioner, at all. The reason why I'm confident the tax wasn't covered is because Mr. Felsted appreciated that it was a Treasury matter. It wasn't a matter that I had influence on. So I doubt it would not have been a subject to me having coffee with him. I can't recall. I apologise for that, but I just can't recall. We had a lot of approvals going on with respect to the hotel. This is some under the Bears Island Agreement Act, whether that was part of it. But most of that was done with Mr. Preston and not with Mr. Felsted. So I just can't recall.
Thank you. In respect of the speed of play issue,
Sorry,
the speed of play issue,
yes.
You gave evidence that you understood that Crown's assertion that the average speed of play of a game with added features was more than 8 seconds was based on GLI testing. Did I hear you correctly?
That's what I recall it was, because their submission was supported by GLI reports. That's what I recall.
So do I understand it from that you thought that part of their submission was based on laboratory testing of the average time of play?
Correct.
Final topic. Sorry, go on.
It's now become an issue in regard to, because the Commission wanted some actual information on how the speed of play of those games had occurred since it's been introduced. And one of the last things oops, I just lost lights. One of the last things, can you still see me?
Yes, we can, thank you.
One of the last things that the Commission was looking at is we weren't satisfied with what they were proposing to present to the Commission in relation to showing how the actual effect of that decision had been. And that was something which I don't know what's going to happen now, because that was going to be followed through after I'd left the Commission. It was an issue for the Commission.
So whilst you were at the Commission, was it ever conveyed to you that in fact at least some of the submissions in relation to the average speed of play of those sorts of games was based on an analysis of actual time that carded patrons were taking to play those games?
Well, I don't think it was, but the trouble with using carded plays is it was based on the time that I understand this, it was based on the time the cards were inserted in the machine. It didn't necessarily relate to how often you were playing. And that was the issues the Commission had, that we weren't happy with that sort of analysis.
Last topic, it's about the gambling statistics that you referred to and the Queensland gambling statistics. And I think based on my inspection of them, they would indicate that Western Australia has the second highest estate per capita casino expenditure, second only to Victoria. And as you've said, Western Australia's per capita casino expenditure has been decreasing since about 2014. The question I had for you was, do you have an opinion as to why that is the case?
The decrease?
Yes.
Look, part of the problem could be that do amalgamate some of the international business, Commission business as part of that data, so that could be attributed to, in part, that effect. But since the 2016 decision of Crown not to continue to bring Chinese patrons to the state, then that has impacted on their profitability. And COVID obviously has had an impact on their profitability as well. I've got lights again.
That, in fact, was what I was going to ask you, was whether the data provided to the Queensland gambling, whatever they are.
It's a government, it's a Queensland, it's a Treasury Department, does it on behalf of all the states.
Yes, whether that did include all casino gambling revenue, including that for overseas players.
I understand it does. Because it's hard to differentiate it out.
So other than that sense that you may have, do you know whether there's been any analysis done as to why Western Australia's per capita casino expenditure is reducing?
No, I don't.
And are you aware of any regulatory changes which would explain that decrease?
No, there hasn't been any imposition placed on Crown. Now, whether it's partly the population is growing, then of course their revenue is not growing too, probably contributing to that sort of data.
Thank you, Mr. Sargent. They were the questions that I had. Yes, Mr. Evans.
Sorry,
Mr. Future.
Commissioner, can I? There is one matter I think I need to clarify. Mr. Sargent, you were asked some questions by Commissioner Jenkins about the tax issue, and I think you said it had not been drawn to your attention. In fairness to you, I need to draw to your attention a document, just so that we get a full picture of your evidence. CRW point 708.017.0305, subject to a non-publication order. You might recall, Mr. Sargent, I asked you some questions about the IGT Advantage system, and I did it in a summarised way.
Yes.
I was in fact relying on this letter in order to put those questions to you, dated 14 April 2009. And then if I could ask that the operator move to the section, the heading on page 0312, treatment of non-cashable credits for casino tax purposes. And underneath that, you'll see there's a few paragraphs there, including an attachment which included the legal advice that Burswood, as it was then called, had received from Malison Stephen Jakes. I won't take you to that advice, but having seen that letter and I think your answer you gave to Commissioner Jenkins was that it hadn't come to your attention, or worse, that effect.
Was that addressed to me? Was it
It is addressed to you. Now, it may not affect the evidence you've given, which is as to your view about whether the revenue falls in or not. The question really is whether any consideration was in fact given to that question by the GWC, and I think you said no, and this might suggest otherwise.
I'm happy to accept that. Thank you.
So if you had recalled that, Mr. Sargent, I was going to ask you whether you recall considering whether the department or the GWC should obtain its own legal advice about whether those credits should be considered as part of casino taxable revenue.
Well, I can't recall it, but obviously, if you were going to do something major like that, we should have got some advice from Sachs Solicitor's office.
Thank you, Mr. Sargent. Yes, Mr. Evans.
Thank you, Commissioners. Mr. Sargent, we will try and be very, very quick. Can I ask you one macro question and then deal with a couple of micro issues in response to the questions in particular from my little friend Mr. Futrell? Can I bring up INQ.130.001? .2034 at pinpoint 2059. Now, Mr. Sargent, this is that Financial Action Task Force document from 2010 that you hadn't actually seen, but I want to ask you a policy question about it. My learned friend, Mr. Futrell, took you to paragraph 95 at the base of, or paragraphs 94 and 95 at the bottom of that page. Perhaps we're going to have 95 highlighted. Now you'll see paragraph 90, can you just read paragraph 95?
I read 95.
And to what extent does that reflect your views on the functions of the GWC and the department in supporting it?
Well, it accords with what one of the core functions of the regulators is.
Now, I'm going to take you to how that interacts with AML-CTF. Now, you've had a number of questions from Mr. Futrell and also from Mr. Garrison, more recently from Commissioner Jenkin in relation to what I'm going to take you to. But you were asked some questions, and I'll focus on 2019, about the media reporting in 2019 and Crown's presentation of the 27th of August 2019. You recall that?
Yes. Yes.
Now, you may recall that the presentation by Crown was preceded in the GWC board papers by an internal departmental document by way of a briefing paper on junket operations. Do you recall that? I'll bring it up.
Mr. Evans, can you repeat that?
I'll bring it up for you. It's GWC.0002, .0016.0283 at 0043. Now, this is a paper authored by Mr. Connolly. It's entitled Junket Processes. It's explicitly in the context of the media allegations. You'll recall that?
Yes. It was after the was it Channel 9 episode on 60 Minutes, yes.
Can I take you down to the last paragraph on that page and the first paragraph on the next page? And in particular, the sentence commencing player probity and following. You read that?
This was a paper prepared by Mr. Donnelly, wasn't it? Mr. Connolly.
That's correct. Now, to what extent does that reflect the view which the GWC then held and had held for some time?
I think it reflects the view for some time, held that view, particularly since the 2010 amendments.
Yes. And what was the fundamental source of information upon which the GWC relied for the formation of that view?
Well, what would have been the chief casino officers at that time, and latterly would have been Mr. Connolly and his advice.
Right, thank you. Now, and to put that in context, in 2010, I think the advice was from Mr. Toyne, because Mr. Connolly wasn't there.
Mr. Toyne wasn't a chief casino officer. It would have been Ms. Belling, I think, would have been the chief. Yeah.
You'll recall there was a paper in 2010 at the time of the regulations being removed, which was, I think, authored by Mr. Toyne.
Mr. Toyne, he disputes the authors, I understand, but there is a paper which has got his name on it, yes.
And he'd also written the National Competition Review, to which you've also...
No, he didn't write that. We employed a consulting economist to do that. We didn't rely on, he wasn't the person to be qualified to make that sort of, he helped him, but it was a report that was prepared by an economist.
Thank you. Now, in that context, you were asked, as a result of that context, I want to ask you a question. The question was asked by Mr. Futrell to the effect that, do you accept that in relation to the integrity of junket operators in Perth, GWC depended upon Crown Perth's internal processes for the assurance of integrity? And you answered yes. I want to ask you the question, does that reflect your view now, in the full knowledge of the events of the last 10 years and the Bergen inquiry, or did that reflect your view up to the Bergen report?
It would have reflected my view probably slightly prior to the Bergen report, but since the Bergen report, definitely.
Right. Prior to the commencement of the Bergen report, who did you think you were relying upon for integrity in relation to junket operators?
Well, we're still relying on Crown executives and their system of risk assessment. But I think as time goes, particularly in the 2020 era, the tide started to change.
Thank you. You were asked some questions about EFT POS or FPOS, that is cashless transactions at tables in the casino from an RSG perspective. Were there any other non-RSG considerations which you took into account other than Crown's commercial interests? Any benefits which accrued from FPOS transactions?
Well, the benefit would have accrued to patrons, the convenience of having that facility. People, at one stage, I can recall when Crown moved away from coin machines to notes. For some people, it was the end of the world. It was just a development of how things have come on. And with COVID, there's such great reliance on FPOS to undertake our business activities rather than carrying cash around. So it was mainly a benefit to the patrons, would be another consideration.
Right, thank you. Final thing I want to take you to is DLG.0002.003.005. Now, this is the document to the ministerial briefing up to then Minister Waldron in relation to the tax reductions. You recall some questions in relation to this?
Yes.
Now, a couple of questions were put to you which were put in terms that this was a submission by you to the Minister. Can I ask you how you would characterise this document?
If you notice down there, it talks about in the second paragraph, you have been provided with a copy of Treasury's briefing note for the Treasurer and have sought comment on Crown's proposal. So there wasn't a submission. I was just taking all the data and putting it to the Minister. And at the very end, it says for your consideration. I think it was no recommendation.
Yes. All right. Thank you. No further questions.
Thank you, Mr. Evans. Mr. Sargent, that concludes your evidence. You'll be pleased to know. Sorry that we've kept you so long this evening, Sydney time. What occurs now is that the summons will be kept in place because it is still possible that Commissioner Owen or the Commission will have some questions for you. But I doubt very much that will require you to return for further oral evidence. I don't want to say it's impossible that will occur because it remains a possibility. But I hope certainly for your sake that doesn't come to any reality.
I'd just love to get back to Perth.
Yes, I'm afraid we are living the dream, I think, compared to you in Sydney.
Well, I've made a family decision to be locked into Sydney rather than be locked out of Sydney. So there are benefits to it, but I'll be glad when I can get home.
Yes, well, we hope that you can get home sooner rather than later as well. Thank you very much for your assistance over the last few days and earlier of this year. The link can now be turned off and you can certainly go about your business. Thank you.
I wish you well. I wish you well.
Thank you, Mr. Sargent. Same to you. We can now turn the link off. The Commission will adjourn now until Monday, the 20th of September at what I believe will be at 11 a.m, a slightly later start. That start will be confirmed with you by the Commission. Public hearings will then resume. Private hearings may be held in the meantime. I also advise that the Commission will be undertaking a site visit of the Perth Casino on a future date. The visit will be facilitated by Crown Perth. To the extent that the visit involves other parties, the PCRC will contact the parties outside of the hearings to make the arrangements. the visit will not be open to members of the public or the media. So thank you very much, Council, for your assistance, and we will now adjourn.